Hey guys, how's it going? I wanted to bring up Stand Your Ground because George is obviously going to be filing it soon, and I wanted to go over it more specifically so that we're not just saying our opinions, but here's the law. So just for you guys that haven't seen it, we're going to go over it real quick. Basically, what it says is at the beginning up here, it just talks about you're justified in using force to protect yourself when it's not deadly. If somebody comes up and starts swinging on you, you can defend yourself. And that's basically what that says there on the top. Over here, where it says, however, this is where it's giving us the right to use deadly force. And it says that a person is justified in the use of deadly force and does not have the duty to retreat if he or she if reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself or herself or to another, or to prevent the imminent commission of a forcible felony. So it just doesn't have to be. I mean, you can use deadly force for a lot of things, but mainly it's to defend other people. And whenever we're talking about that, when we're showing people how to use a gun and stuff, we'll let them know. We don't use. We're not going to shoot people for property. They do that. Some places they do that, and I know in Texas, if you steal somebody's car, they can shoot you for it. Yeah, we don't really go that far here in Florida. We would rather say, that's why we have insurance. Not a big deal. Let the guy get away with the car. I'm not going to kill him over a car. But over, if I come up on a rape or something like that, and the only way that I can protect that person that's being raped, then I have to use the gun, unfortunately. So, basically what it says is you're allowed to use deadly force if you reasonably believe that such force is necessary to prevent the great bodily harm or stop a forcible felony. And under those circumstances, it's permitted under the state law 776.013. But then you go on down here, and it gives you the specifics. This is the home protection, and that is 013. Basically, that gives you all the normal stuff. Everybody knows what the home protection is. I mean, if someone comes in your house, you have the right to defend yourself, and you don't really have to check it out. You don't have to decide whether they're a threat or not. But I didn't want to spend a lot of time on that because that's a whole nother issue. But I mean, if you want to read it, it's here. I'm just I'll scroll through it. You can feel free to stop it and read this stuff if you want. That's all got to do with dwelling. So here comes 0.032 is the immunity, and this is what's important. That George is not going to be, if he wins his defense, he will not have to. He won't have any issues with civil court or anything like that. It says, I mean, you guys can read it for yourself. But it just says that if Trayvon's parents try to sue him or anything like that, that wouldn't happen. There would be no more. He would be done. There's no criminal prosecution, no more anything. And you can see here, it says, as used in the subsection, the term criminal prosecution includes arresting, detaining in custody, and charging or prosecuting the defendant. So this law actually is being broken because they are prosecuting him against the law. I mean, the DA's office already said no, so the governor is breaking the law. And one thing I found interesting is the court's supposed to award a reasonable attorney's fee, court cost, and compensation for loss of income and all expenses incurred by the defendant in defense of any civil action brought by the plaintiff if the court finds that the defendant is immune. So if somebody does try to bring a case against him, they're going to be paying out the nose. All right. Now it's use of force by aggressor. This is something that's interesting because a lot of people keep saying, no, he's the aggressor. He can't use it. He's not allowed. Not allowed to use stand your ground if you're the aggressor. Well, I've heard that on TV. There's a lot. And I was going to bring up the clips and show the guys, the lawyers and stuff that said that. But I'm not interested in doing that. I don't really feel the need for that. Maybe someday I will, just for fun. But I just wanted to show that it's true that you can be the aggressor and you can use stand your ground. And I'm going to show you right now. As we see, it says the justification is not available to the person who is attempting to commit or committing or escaping from the commission of a forcible felony, or the person who initially provokes the use of force against himself, or unless, here's what's the important part, unless A, such force is so great that the person reasonably believes that he or she is in imminent danger of death or great bodily harm, and that he or she has exhausted every possible means to escape such danger other than the use of force, which is likely to cause death or great bodily harm to the assailant. B, in good faith, the person withdraws from the physical contact. Somebody who's trying to get out of the fight, even though they might have started it. You can still use stand your ground. If say, for example, you walk up to a guy and say, "You stupid jerk," and you just start swinging on him, and he starts swinging on you, and you get into it, and it's a big fisticuffs. I mean, going at it, both of you. And he knocks you down to the ground, and you're laying on the ground, and he's busting your head on the concrete, and you're crying out, "Okay, okay, I'm done, you win." And the guy just won't stop. He's swinging on you and smashing your head on the concrete, and you, "Okay, okay, I said you win, quit it now, you're killing me." And the guy won't stop, so he keeps going at it. So you pull out your gun and you blow a hole in between his eyes. Then it is justified. See, this is what I'm saying. A lot of people didn't know that. And here it is in the law. This is .041 of the law 776. So if you want to find out about it, if you want to know the law, it's here. And basically in Florida, all of our laws are real short. So when you're trying to find out a Florida law, or you want to know what the Florida law is, you can just go right to the internet, and you can pop it up, and it's in plain man English. Makes it real easy for everybody to understand. It's a lot more fun. That way whenever the cops give you a hard time, and if you know the law, and if you printed it out, you can pull it out and say, no. That's not the law. Here's the law. Because, you don't expect the cops to know the laws. They can't. They're not lawyers. And the lawyers don't even know the laws. I mean, if a lawyer takes a case, he has to study for that case. Lawyers just understand concepts and procedures and stuff like that. That's what they study for. They don't study to learn all the laws. Believe me, that's why they have all those law books, not because they read them. I mean, yes, they study cases. They want to know case law so that they can easily find arguments for certain things. I mean, if you're a lawyer and you're constantly fighting a certain kind of case, then you would start to memorize these case studies, cases that have gone by in the past. So anyway, I know we're going to have a great debate about this stand your ground. I know a lot of people are going to probably nag me on this video and call me all kinds of names, but that's all right. I don't mind. Just bring the conversation. Let's talk about it. Anything you guys want to talk about, stand your ground. You want to talk about George, I'm here. Sounds like fun. Talk to you later. Bye.